As promised, here's your Monday update for this week. And today we're going to be talking a little bit about some of the questions that we have been hearing on behalf of hosts and platform providers and property managers over the last week. So we're trying to be transparent about what we're doing, why we're doing it, and why some of this is going to make a lot more sense once it's explained. And hosts are struggling to understand their rights, to understand what their options are. We're trying to do our best to empower hosts, to educate hosts, to help hosts understand what their legal rights are to arbitrate under the terms of service against Airbnb for COVID-19 refunds that violated the strict cancellation policy of hosts. So let's just take a quick look at this provision here, 19.4 in the terms of service. And this is going to answer one of the primary questions that we're getting, which is, well, what if the terms of service say that I lose? What if the terms of service say that Airbnb can do whatever they want? Airbnb is too big. Airbnb, we can't fight Airbnb. None of these things are true. You have an absolute right to arbitrate against Airbnb. And Airbnb's terms of service allow the arbitrator to determine the applicability, breach, termination, validity, enforcement, interpretation of the terms of service. So Airbnb anticipates there's going to be disputes. This is one of them, and empowers the arbitrator to determine which terms, which policies are enforceable, which are valid, and which are invalid. You and Airbnb agree that the arbitrator will decide those issues. So none of this is unexpected. There is a long history of arbitrations with Airbnb under this provision, and it's all contemplated and expected between contracting parties and between platform providers and users. If any of the provisions of the terms of service are found by the arbitrator to be invalid or unenforceable, then the arbitrator simply strikes those provisions from the agreement. So I think that's really important, because I think that there's a sense that that the platform provider has all the advantages, and that is not necessarily the truth, and it's certainly not the truth in this instance. So for our May 11th update, let's just take a look at some things here. We're going to look at some frequently asked questions, the real story, and remind everyone that the collective action that we're trying to empower for hosts is 10,000 hosts filing 10,000 arbitrations under the terms of service. Challenging Airbnb to account for hosts, to be accountable to the terms, to be transparent in their decisions, and to actually follow through on the things that Airbnb agreed to when hosts agreed to use their platform to book reservations. So let's take a look at some frequently asked questions. Why assert your rights? We're handling arbitrations on behalf of qualified hosts, property managers, platforms on a contingency fee basis, as long as the damages are sufficient enough. There are a couple other factors, so always contact us if you have any questions. But basically, if the claims are big enough, we'll handle those cases on a contingency fee basis, which means you simply pay the $200 filing fee and we handle the rest. So why assert your rights? Well, look at hosts and guests had already agreed to a 50-50 split of risks caused by pandemic, meaning when they booked that reservation under your strict reservation policy, they understood that if a pandemic occurred, that there'd be a 50-50 split on the loss. That as long as it was outside the 7-day period and not in the 48-hour period after the reservation, that the guest would pay 50%, the host would only receive 50%. Hosts were entitled to work with guests with their questions and their request to change as a result of the pandemic. They had the right, the hosts and the guests, to change any of the risk allocation without interference by Airbnb. You had, under the terms of service as a host, the right to try and work with guests to solve any problems caused by the pandemic without any interference by Airbnb. And of course, that's not what happened. They stepped in and they incited cancellations for their own purposes, they made a calculated decision to refund what appears to be $2 billion of host payouts for its own purposes, for Airbnb's purpose of increasing its valuation for investors and to increase its valuation on its delayed IPO. This was not a do-gooder, we're trying to protect people situation for Airbnb. This was them taking money belonging to hosts and giving it back to guests in violation of the terms of service so that they can increase their own valuation, so that Airbnb could line its own pockets, and they did it at the expense of the hosts. So why assert your rights? There's a couple of reasons that we're hearing from hosts as to why they're pursuing arbitration. So we already took a look at your right to arbitrate under the terms of service under Section 19. It's already set forth. You have a contract with Airbnb giving you the absolute right to arbitrate your claims. You certainly have the right to do that without penalty or retribution from Airbnb, and to have the arbitrator decide outcomes on legitimate disputes. All right, let's talk a little bit about what I really have not spent a lot of time on, except in individual calls with hosts who have reached out to us and who I've spoken to, over 200 hosts and property owners by phone. What is the basis of the claims against Airbnb? And I made the decision to share some of this information so that other hosts, hosts with smaller claims, can understand the legal basis of an arbitration claim against Airbnb. We promised we were going to be transparent. We promised that we were going to be enabling hosts to make decisions about their rights and about pursuit of claims, and that's what caused us to decide we're going to share some of this information today. All right. Keep in mind, Airbnb is just a booking platform, and you'll hear from Airbnb. They always tell the municipalities it's just a booking platform, right? We just have users. We don't do property management. We don't host properties, right? It's neither a host nor a guest, nor does Airbnb act as a host to its guest. You do, right? Airbnb has users of the platform, and the terms of service identify not owners of property, right, but users of the platform, and they have different classes of users: hosts, co-hosts, travelers. All right, so you're the host, you have the one that has the guests, you're the ones with the customer service and the customer relationship, and you are using Airbnb as a reservation or booking platform to be able to offer up your home and make good on your substantial financial investment in your business. Your guests rate you, you rate your guests, no one rates Airbnb. Your guests pay for the reservation. That reservation money minus the platform fee belongs to the host. There is no legal argument that it belongs to Airbnb or that Airbnb has any legal rights in the money, the reservation payout, that is paid by travelers, your guests, their travelers, to hosts. So Airbnb simply processes the transaction. It's similar to a kind of an escrow agent. It's acting in the middle of the transaction in a very limited role between you and your guests to make sure that you make good on your promise that the property is going to be habitable and available. And then its only obligation is to process the payout consistent with your cancellation policy. It's a very limited role of Airbnb as a platform. All right, your agreement with Airbnb is pretty limited, as we've just gone through. So you picked your cancellation policy, and Airbnb represented to you that you could build your business and rely on that policy. It is perhaps the most material term in the contract for hosts. They pick the reservation policy, and they can plan, and they can accept or reject risks by choosing the policy that works for them. It's a big draw. It's a big marketing push by Airbnb to get you to use their platform. Now it turns out they want to say that it's meaningless and they can do whatever they want. It was just misrepresentation, marketing fraud, that there is a cancellation policy that means something. Their position now seems to be that, hey, we can do whatever we want if it's in Airbnb's interests. There are billions of dollars in play here. And hosts have incredible investments that they've made in their businesses. Regular people have made incredible investments in their properties in order to act as hosts, in order to be great at customer service. Airbnb is just a platform. So your guest, so you picked your policy, and your guest had choices to the cancellation policy. They could pick a flexible policy, they could pick a moderate policy, or a strict policy. When they picked that strict policy, they agreed to split the risk 50-50. So it's a fair allocation 50-50 with guests, right? And if there needs to be some sort of adjustment to that, that's up to you, not up to Airbnb. So Airbnb, is really acting as though it has the right to issue these refunds in the way that it did, inciting refunds. But that's really not what the terms say at all, and that's not what the law allows. And here's really some basic concepts that you're going to need to understand for pursuing your arbitration claims. Terms of service that are unreasonably vague are unenforceable. These click-wrap agreements are the things that no one ever really reads, right? You have to say, I agree, before you get into the platform, but the terms of service are rarely read, and they've got the statistics on who actually click through to these things, and on a percentage basis, it's going to be some incredibly small decibel of 1% of anyone that looks at the terms of service when they sign up. And they know these. They're called click-wrap agreements, and so courts, arbitrators in this instance, are empowered to determine what, if anything, within the terms are enforceable. To the extent that a particular item in the terms of service are unreasonably vague, they're unenforceable. It's a basic construct of contract law, and so that means if the term is unable to be interpreted objectively to mean something very specific, then you can't enforce it as Airbnb. And so we'll talk a little bit about why that applies to this I can do whatever I want term within the terms of service that Airbnb says, hey, look, we've got terms that say in our sole discretion we can do whatever we want. Well, that's unreasonably vague. We don't know what that means. We don't know how that would change the relationship. Does that mean that nothing in the contract is enforceable if Airbnb decides it's not? These are the types of click-wrap agreement terms that are very often found to be unenforceable. Terms of service that are inconsistent with other language on the website are unenforceable. So whereas people don't actually click through to the terms of service, they do walk through the process of adding their listings, and they do pick the cancellation policy. And the marketing around your ability to pick a cancellation policy is far more prominent and far more defined than anything in the terms of service. And so they market to you the right to be able to build a business around the strict cancellation policy. You agree to it, you select it, your guests see it and agree to it. That's the policy that should be in place. And so even before you get into, well, is this or is this not an extenuating circumstances, our position is it's a 50-50 split of risk between hosts and guests for a pandemic, period. Any changes or modifications can only be made by the hosts. There's also a contract principle called illusory terms. Terms that are illusory are unenforceable. We'll talk a little bit more about that in a minute, but essentially if it's not definitive enough, if it's not defined enough, if you can't, if it means that someone can simply change the terms or change the mutual obligations of the party at any time, then those are illusory terms. And we, in our firm, we've litigated class action lawsuits against platform providers based on these very concepts here, and won substantial verdicts and punitive damage awards in those cases. Okay, we've already talked about at the beginning that the terms of service already tell you that the arbitrator can decide what terms are enforceable, whether the terms are enforceable, and interpret what those terms mean. And to the extent there's inconsistencies in the language, the arbitrator gets to decide those issues. Okay, let's talk a little bit about this extenuating circumstance policy. I'm concerned that it's become too big of an issue in the sense that the debate is really focused in on this initial discovery that we made and that Intel made about the fact that they changed the wording from endemic to pandemic and then tried to hide that from hosts and from guests and from the public. That was bad. That was really a major red flag as to the true motives of Airbnb, but it really is a secondary issue. The 50-50 split between guests and hosts on risk for pandemic is the dominant issue. I don't think we ever get to the extenuating circumstances policy, but let's take a look at it. We say that it is unenforceable because it's unreasonably vague. And here's just an example of one case so you can see how this works. A subordination agreement is a terms of service. It's an agreement that is akin to a terms of service, a click wrap agreement on a website that few people read. And so here's a quote. In recent years, terms of service have frequently been reviewed by appellate courts with respect to the issue of uncertainty, materiality, and fairness. Where the subordination provisions have been found uncertain and incapable of ascertainment by reference to an objective standard, they are deemed unenforceable. So that's what we have here with this EC policy, right? The ECP. What does it mean? Whatever Airbnb wants? Well, that's really uncertain. Is there any way to ascertain what that will eventually mean to either hosts or guests under an objective standard where you could say that was an appropriate refund and that was not? Well, let's just put aside the issue that Airbnb doesn't even disclose to you the basis of its decision or whether it even reviewed any information, or the fact that the guest has already admitted that it wouldn't fall within the extenuating circumstances policy before Airbnb decides to give a refund. Putting all that aside, this is a material provision of the contract which is incapable of having an objective standard applied. And so this is the type of case that is going to be used on offense in an arbitration proceeding. All right. There's also a concept under contract law of illusory contract terms, and it's a promise that's unenforceable because it's indefinite, or there's a lack of mutuality, meaning one side can do whatever it wants, where one side is bound to perform, but the other side can change the terms midstream. So one example would be, hey, look at, you're going to agree to sell me ice cream, and I can buy however much I want or none at all, but you have to sell to me. It's an illusory contract. It sounds pretty familiar, right? There's going to be a strict cancellation policy, but Airbnb is going to decide whether or not it's enforceable or not, whether refunds are going to be granted or not for any reason Airbnb decides in its sole discretion or not. That is an illusory contract term under law from my point of view, and that's what we're going to be arguing on behalf of our hosts. Even if the EC was enforceable, Airbnb admits that pandemics were not included in the policies that existed at the time the reservations were made between you and your guests. Okay? Airbnb tried to change that policy, hide the changes, and then pretend that policy controlled the situation. In fact, it added a little header at the top of its extenuating circumstances policy in March saying, the policy doesn't apply. Now we're going to, in March, come up with a brand new policy we're going to apply, even though your contract with your guests became a contract at the time of the reservation. And those terms can't be changed by Airbnb. So Airbnb failed to follow its own policy requiring 30 days notice before a change can become effective. In the terms of service, Airbnb has to tell you 30 days before it makes a change in a term or in a policy, such as the EC, and it can't become effective for at least 30 days, and it certainly can't be applied retroactively to modify your existing contract. So all of those things happened here, and they all provide fertile ground for legal arguments and a basis for an arbitrator to hold in the host's favor. There's another little nuance here that's come up with a lot of hosts, and we're hearing a lot of complaints on it, and it really comes down to this interference of Airbnb between the relationship of hosts and guests. Nothing in the EC or terms allowed Airbnb to convert your reservation fees by way of an Airbnb credit. So there's no theory by which Airbnb has any interest in the reservation payout fees to hosts. And yet it took those for itself and it told guests you can get a credit for that money, which we're going to hold on to. We're going to actually charge a credit card. We're going to take and convert that money belonging to hosts for ourselves, and then, hey, if within 12 months you want to use that at another Airbnb property, we'll give you that credit. That's conversion. It's called conversion of property. Airbnb converted your money to its own purposes. And what happens when the guest doesn't use that credit? Airbnb, who has no interest in that money at all, now receives that money for itself. The other thing that's out there is there's a process that Airbnb was required to follow for refunds. So even again, if this EC policy exists, there is no contract term that says Airbnb can proactively encourage or incite guests to cancel their reservations. Under the policy, the guest had to go through the process on its own of canceling and then make an EC policy request within, I think, 14 days. And then Airbnb had to vet those claims and paperwork for those claims before making a determination. Now, that determination could never just be whatever Airbnb wants anyway, but forget that. It never even went through that process. It never let hosts deal with the situation as you as hosts had a right to do. It blew up everything by simply encouraging and advising guests that they should cancel, essentially, and that they should take a credit, ultimately, if not a refund. So what is the real story here? And I think that this is really important. It's not about hosts and guests. This isn't hosts versus guests or anything like that. If Airbnb decided that it was going to increase its valuation by giving guests a credit or paying compensation to guests, it had to do so out of its own coffers. It could not convert the money of a host for its own purposes in order to increase its own valuation. So Airbnb decided that if it wanted to distinguish itself from other competitors, from other booking platforms, that it was in Airbnb's interest to do what other booking platforms were not doing, to interfere with the contract between guests and hosts, to increase its own valuation. If Airbnb made that decision, it had to foot the bill. It took $2 billion in money belonging to hosts with strict cancellation policies and essentially bought $2 billion worth of goodwill for Airbnb. So even for the guests who aren't going to convert, who are going to use the credit, right? It's still used money unlawfully belonging to host to build its own valuation. You have the right to ask for discovery in arbitration. We're asking for discovery on behalf of all of our clients, and that discovery will be all the documents and emails that reveal the true story, the real motivations behind what Airbnb did, the fact that it wasn't some altruistic effort, but it went down to increasing its own valuation for a future IPO. That is going to be considerable leverage with Airbnb. They do not want that information to get to hosts and certainly not to get out into the public. All right, so let's talk a little bit about this 10,000 host and 10,000 arbitration play that is being made here. We are building this platform, as we've been telling you about, that will help hosts with smaller claims who really can't afford counsel to do all this for them and to get their best legal arguments in play and to maneuver through the process and against Airbnb day in and day out. But we're going to build them this platform where they can engage in self-help to be able to assert their legal claims. 10,000 hosts, 10,000 arbitrations is going to send a message to Airbnb that hosts need to be accounted for. All right, my name is Enrico Schaefer. You can find me at traverslegal.com. We've got a section devoted to Airbnb arbitrations brought by hosts and by property managers. I invite you to share this video, share this information, empower fellow hosts. Let's make this moment in time count. Airbnb says you are not allowed to engage in a collective class action or a collective arbitration, but they can't stop you from acting collectively. And that is the real magic of what's happening right now by hosts like you. Thanks, and we'll see you next week. If you have any questions, feel free to contact me. I'm happy to talk to all hosts.